If you use these 4 words during a traffic stop, it will force a cop to either let you go or he'll have to justify why he's holding you. I'm Jeff Hampton, and in this video, I'm going to show you what to say, when to say it, and how this new Supreme Court ruling makes it more powerful than ever to use these 4 words to end a traffic stop. A new unanimous Supreme Court decision has now shifted the balance of power during a traffic stop. In the U.S. Supreme Court case of Barnes versus Felix, the court changed the rules about how we can evaluate police officers' behavior during not only a traffic stop, but any encounter with a cop. Under the new Barnes ruling, everything the police do, from the moment they light you up till the moment they detain you or even try to use force against you, can be evaluated and used to determine if that police officer acted reasonable. This shift makes the 4 words I'm about to share with you here in just a moment even more powerful for motorists who want to protect their rights during a traffic stop. So let me break down why this Barnes decision is so important and how it changes things for us. Number 1, I want you to realize the court now says the officer's entire conduct from the moment they try to pull you over until the end of the encounter, their behavior, their justifications, their actions, everything they say and do can now be scrutinized to determine if the officer acted reasonable. In fact, the Barnes case all started from a minor traffic stop based upon unpaid tolls, but yet the case turned deadly. A constable by the name of Deputy Felix stopped Barnes claiming he had unpaid tolls. Now, of course, he was driving a rental car, which is another issue altogether, but during this period of time, Barnes was fumbling to try to find his license. Deputy Felix then started feeling suspicious because this man couldn't locate his license, so he ordered Barnes to get out of the car and Barnes tried to take off. But then Deputy Felix, he did something kind of strange. He actually jumped onto the moving car. And in the process of jumping onto the moving car, he fired 2 shots into the windshield, which ended the life of Mr. Barnes. Of course, Barnes's family sued, claiming that in this situation, the police officer was using excessive force. And even though the 2 lower appellate courts ruled in favor of the police using an old standard, a unanimous decision written by Justice Kagan changed the rules for everyone during a traffic stop. The Supreme Court changed the standard with Barnes when Justice Kagan wrote a unanimous 9-0 decision here, where she looked back and said in the past, those lower court decisions were relying upon what's known as a moment of threat analysis, which means they used to not look at the full context of what a police officer did during an encounter. They only looked at the moment where things went south and determine if the police officer did right. But now they've changed the rules. They now say that you've got to look at the entire event, everything that took place, to determine if the cop acted reasonable. I'm going to read to you some of the quotes that Justice Kagan said. She said, a court must, quote, consider all the relevant circumstances, including facts and events leading up to the climactic moment. In other words, context is king. Justice Kagan then went on to say, a court deciding a use of force case cannot review the totality of the circumstances if it has to put on chronological blinders. So what does this mean for you as a driver during a traffic stop? It means police can no longer get away with ignoring their own actions leading up to a traffic stop or their poor decisions leading up to the moment of encounter. Every decision now counts when a police officer pulls you over. Think about some of the things that they have to do that we can now evaluate that didn't exist prior to Barnes. For example, number 1, the basis for the stop, the officer's tone and commands to you during the stop, whether they prolonged the stop, how they reacted when you asserted your legal rights. All of these now count in determining whether the officer acted legal and reasonable in his behavior. This is a huge win for accountability, and it helped close a loophole where officers used to use bad tactics and bad behavior to do what I actually would think of as baiting a driver into responding a certain way so that it looked justifiable in the heat of the moment. The ruling in Barnes makes it crystal clear from the Supreme Court. The actions of a police officer during a traffic stop cannot be viewed with tunnel vision without considering everything else that took place. Now, to be clear, there is a separate total legal analysis when it comes to use of force that I'm covering on a different video, but I want to tie together this new Barnes decision to your traffic stop rights so that we know the 4 words you need to use to completely protect yourself and stop the police. So in order to tie Barnes into your traffic stop rights, let's look at 2 of the most important cases involving traffic stops so that we can take these 2 cases, tie it to Barnes, and give you protection. The case of Delaware versus Prowse. In this Supreme Court case, it was ruled that police are not supposed to and are not legally allowed to pull you over to fish for violations. This only makes sense, but if police are going to pull you over, they need a legal reason to do so, like a traffic violation or some reasonable suspicion to believe you are involved in a crime. Otherwise, it's nothing more than a hunch and it's illegal. Our next case is Rodriguez versus United States. And in this very, very important U.S. Supreme Court case, it changed traffic stop law forever. It basically said that when police officers pull you over to write you a ticket for a traffic violation, they cannot prolong the traffic stop beyond its original mission, i.e. writing you the ticket, unless they have separate reasonable suspicion that you've committed some other type of crime. In short, Rodriguez said, cops can't just pull you over claiming to give you a traffic ticket, only to hold you to see if you slip up and arrest you for something else. So, what are the 4 words, the 4 magical words that when you combine them with this new Barnes decision can help you end a traffic stop? Here they are. Am I being detained? By using these 4 specific words, you are forcing the officer to confront the principles that were just laid out by Barnes. In fact, when you say, am I being detained, you're really saying, officer, do you have any lawful reason here to be holding me, or am I free to go? Because here's what's key. When you use these 4 words, cops know that if they don't have a solid reason to hold you, per Prowse, the case we just cited, they should let you go. And if they do have a legal reason, your 4 words just reminded them that the clock is ticking. They cannot hold you any longer than the original reason for the stop based upon Rodriguez. And now with the Barnes decision that just came out, cops also know any attempt to drag this out or go on a power trip with you is all going to be evaluated in court to determine whether the officer was being reasonable. In other words, these 4 words, am I being detained, puts the cops on notice that I know my rights and I'm going to hold you to the rules. Now I know what some of you are thinking. Some of you are saying, come on, Jeff, I've heard and I've watched your videos before. I've heard you say, am I being detained? Those are simple words. Why does it make it so powerful here? They might sound simple, but after Barnes, they're like legal bulletproof vests for you during a traffic stop. In fact, let's break down the power of each of these 4 words. Let's start with am. This is a present tense verb, which means you are asking about what is happening right now. This is crucial. By using the word am, you are inquiring to that police officer if you're being detained right now, not in the past, not in the future, but presently right now. You are demanding an instant status check on your freedom in that moment. You're putting the officer on the spot to give you a response about your freedom right then and there. It's important to put that officer on the spot to justify that current situation. But because courts during traffic stops have really focused on your rights in the moment of the actual altercation. For instance, in the Supreme Court case of Berkmer versus McCarty, the Supreme Court said, and I quote, that a traffic stop curtails a person's freedom in the moment, even if briefly. So the question of detention is inherently a present tense issue. We just covered am, so our next word is I, and this is personal. By saying I, you're making it very clear, eliminating any ambiguity about who you're asking is being detained. We're not talking about passengers in the car. We're not talking about anybody else on the scene. You're talking about you and only you. This is really important because police encounters can sometimes involve multiple people, whether it's in a car or cops walking up to you. And you got to watch out because cops like to play word games. For example, I've heard cops say things like, no, we're not detaining anyone, or everyone just hang tight. They like to speak to everyone as a group and not specifically talk to an individual person sometimes. Using the word I pins it down. Are you, officer, detaining me? It's an assertion of your individual rights. This ties back to other Supreme Court cases where the Supreme Court has said, like cases like Florida versus Bostick, where they made a determination that the test for a detention is whether a reasonable person in that individual's position would feel free to leave. By spotlighting yourself, you're making it crystal clear that you're demanding whether that officer has the authority to hold you and no one else. This brings us to our next word, word number 3, am I being? This word zeroes in on the ongoing action or maybe inaction of the cop. Being detained, dodges the question from the police officer of trying to talk about the past or in the future, and it puts everything in the moment. This is really important because police officers are trained to try to deflect against you. They'll say things like, well, you could be detained if you don't cooperate. When cops say things like that, it's hypothetical and it's only looking into the future. By asking, am I being detained, it makes it crystal clear you're speaking about the present, not about something in the future. And it helps establish the legal standard in reference to an actual seizure under the Fourth Amendment. In the United States versus Mendenhall, the U.S. Supreme Court ruled that a seizure occurs if a, quote, reasonable person would believe they are not free to leave at the moment. By asking if you're being detained, you are invoking the Mendenhall standard. And finally, our fourth word, detained. This is the clincher. The word detained is a legal term under the Fourth Amendment. It refers to a temporary seizure of a person, less than an arrest, but more than a consensual encounter. By using the word detained, you are showing the officer you know that this is a Fourth Amendment situation. You're basically asking, officer, are you officially invoking your authority to limit my freedom right now? Or are you trying to pull a voluntary encounter on me? If the officer says, no, you're not detained, then you are free to leave, and I would leave immediately. Don't meddle around with the cops. But if the officer says, yes, you are detained, they now must believe they have legal cause. Reasonable suspicion of a crime, per Terry versus Ohio, they must believe they have reasonable suspicion to hold you. And by the way, if a cop thinks he has good legal reason, a good cop should have no problem sharing what that so-called legal reason would be. If an officer cannot articulate a legal, lawful basis to hold you, then they shouldn't be detaining you. And an officer will realize that when they don't come up with a good reason. Essentially, the word detained is like a mental trigger for the cop. It forces him to internally, realizing he's on camera, to internally decide, do I have the legal reason and ability to actually hold this person? So in one polite, four-word question, you've accomplished a lot. Number one, you're forcing the officer in the moment to justify what he's doing and make a decision one way or the other to let you go or to detain you. But you're also clearly making a record that you know your rights and you're asserting your rights for protection. Headlines are shouting at you from every direction. Bias, censorship, outrage. It's overwhelming. So how do you cut through the noise and find out what's really going on? That's where Ground News makes a difference. Ground News gives you the freedom to discover for yourself whether what you are reading is unbiased and fair, so that you can come to your own conclusions. Isn't that what the news is supposed to be about? Check them out for yourself at groundnews.com/Hampton. Let's take the received news story that John Cornyn revealed the FBI has agreed to both locate and arrest Texas Democrats who left the state this month to block voting on redistricting legislation. As we analyze the coverage in Ground News, the top right displays key details, the number of sources reporting, their political bias breakdown, reliability ratings, and ownership info. These insights show how outlets across the spectrum are framing the same event differently. One of the most powerful features of Ground News is the headline comparison, where we can see for ourselves how different news outlets are framing the story. By clicking on the left, center, and right, we can observe the language and tone used, allowing us to draw our own conclusions. For instance, a left-leaning headline might focus on threats to democratic norms, while a right-leaning headline might emphasize enforcing the law. But my favorite feature is the blind spot feed. With blind spot, you can see news stories that are disproportionately being covered by one side of the political spectrum. In our polarized environment, I have found this feature to be an amazing way to discover stories I would have never seen because only one side is talking about them. It's also perfect for better understanding friends and family who think and see things differently. The best part? Ground News has a special offer for my viewers. If you sign up through my link, you'll get an amazing 40% off the Vantage plan, the same plan I use to get unlimited access to all features. Go to ground.news/Hampton to give it a try for yourself. Click the link down in the description or scan the QR code to stay better informed and transform how you read the news. But how does saying, "Am I being detained?" after the Barnes decision become even more potent now when you're defending yourself from the police? Well, number one, remember the officer must now justify the stop or let you go. Remember, the moment you say, "Am I being detained?" it makes it much more difficult for the police to go on some fishing expedition or to try to wait around and stall you to go get a drug dog. It's very common for police officers to string you along with chit-chat or vague instructions that might make you a little bit confused, that now might make you incriminate yourself, or maybe the officer can use your expressions or responses as a way to claim you're acting suspicious so that they can search your car. But after the Barnes case, and now you using the words, "Am I being detained?" it becomes a dangerous game for the police to prolong your traffic stop. Prolonging the stop without a solid legal reason now puts the police officer in peril, because when he's questioned about it on the witness stand and he couldn't give a good answer for it, there's a better chance that any evidence collected could now be thrown out in court. Remember, Delaware versus Prowse taught us that random or unjustified stops are illegal by the police. And now the Barnes decision also says that if the cops get out of hand and they mistreat you, and maybe they use force against you, that can be used. Their pre-force activity, their pre-force behavior of basically using fishing expeditions and violating your rights can be used against that police officer in a possible civil rights action as well as possible criminal action against the officer. Situation number 2 is that during a traffic stop, cops can no longer perform those fishing expeditions because time is now evidence you can use. One of the biggest lessons from Barnes is that time now matters during a traffic stop. The longer a stop drags on without justification, the worse it looks for the officer. The Supreme Court in Rodriguez versus U.S. made it crystal clear that police officers cannot extend a traffic stop beyond its original reason for like a traffic ticket just to fish for other crimes. But Barnes now flashes a spotlight on that rule. When an officer tries to stall a traffic violation for no good reason, K-9 unit, checking on something real quick, it actually leads to a Fourth Amendment violation. The problem is, how do we know if that time frame is prolonged to the point where it's illegal? That's where using those magic words of "am I being detained" starts the clock timer. You're not only signaling to the cop that you know the law and that you won't be jerked around during a traffic stop, but you're also making it clear this is not a consensual encounter and the time for being illegally detained is now clicking. And the longer this time clock begins to extend, the more likely it will be ruled unconstitutional. And finally, if you record everything during the traffic stop, it will be clear and uncontestable evidence if it needs to go to court, particularly if the officer uses force against you. This is so important, why I advocate using your own dash cam. Make sure you use your cell phone camera if you can, and don't always rely on the officer using his own body camera. Because think about this. What if you do everything right that we're covering on this video, but the cop all of a sudden decides he's going to escalate the situation unreasonably? He's going to ignore your questions. He's going to be tense. He's going to make unlawful demands, and maybe he's going to ignore your all unlawful questions. By you now following all the rules we've talked about here and recording all this behavior, if the cop now tries to use force against you, you now have all the law in your favor, and it now makes it 10 times more likely the officer's actions will be ruled to be unreasonable, and qualified immunity could be potentially stripped away, and you would have a cause of action. So finally, we've covered the law. We've talked about how it applies, but what happens when the heat turns up and now the officer's being aggressive with you? The first thing you want to do, if an officer comes up to your front window and you're following the law, you're doing everything you can, you're even being polite to the officer, and he starts being aggressive with you, the first thing you can do is remember, hand the officer your license, your registration, and your insurance as required by your state law, and then you don't have any other responsibility to do anything else. If the officer starts escalating the encounter, you can always invoke your right to remain silent. You can always invoke your right to counsel for any other questioning. But if the officer continues to hold you on the side of the road and he's sitting there and he goes back to his cruiser, and you're continuing to wait, and then he walks back up again, and this is a prolonged period of time, remember, it's at that moment you say, "Am I free to go? Am I being detained?" Our magic words, am I being detained? We use those "am I being detained" specifically here. If he says you're not being detained, you say, "Officer, based upon that information, I'm now going to leave the scene." You record every bit of this and you drive away. If, on the other hand, the officer says, "Yes, you are being detained," the next question out of your mouth is, "Officer, may I ask, on what specific legal grounds?" Here, you're recording everything and you're forcing the officer in the moment to state the legal reason for you being detained. In that moment, the cop might say, "Well, because you're speeding," or because I smell marijuana, or there's an alert on your license. Whatever it is, it's very important because now they've stated the legal basis for the actual detention. After they state the reason, which is very important because the reason itself, particularly if it's a traffic violation, limits how long they're able to continue to keep you on the side of the road. I would much rather the officer articulate what that reason is than for him to come up with his own reason later on in a police report or under oath. So it's important that you ask that question. But if the officer gives you a specific reason, we now follow the next steps. You should then immediately invoke your core rights. What are those? Well, the first thing I would say is, officer, I refuse consent to any search of my person, my places, or my things. So any of those things, your person, your property, anything that you have there, your vehicle, anything that's there, you need to refuse consent to search. Then number two, I would then say I also exercise my right to remain silent, and I will not answer any further questions unless my attorney is present. After you have invoked those rights, I would zip my mouth and not say another word. Now, the only example I can give to you to say that you should say something else is if the officer continues to hold you on the side of the road for a prolonged period of time. I've seen this happen with drug dog searches where a cop literally holds somebody on the side of the road 3, 4, 5 hours on the side of the road. And as they're sitting there waiting for a drug dog to show up, it's important, as you record the entire encounter, you can ask the officer again, am I being detained? That's all you say. And if the officer says, yes, you're being detained, you re-invoke all those same rights we just covered. If for some reason he says no, you drive away. By continuing to say, am I being detained? Every 30 minutes to an hour or so, you are setting a very clear legal record that this officer is exceeding the scope of the constitutional rights, that he is now trampling on your constitutional rights by not releasing you because he's violating Rodriguez by keeping you on the side of the road. So before I finish this video, I know that some of you are going to say, come on, Jeff, these magic words aren't magic in every situation. And you're right. Let me give you a very few quick examples of where am I being detained will not work. Number one, DUI checkpoints and roadblocks. If you're stopped for a DUI checkpoint, here the rules are a little bit different. The Supreme Court has ruled that police officers during a DUI checkpoint don't need an actual separate reason to pull you over during a checkpoint. The checkpoint itself is the reason, and unfortunately, the Supreme Court has said this is legal. Using the words, am I being detained during a checkpoint won't work. So here's what you do instead. Once you pull up to the checkpoint, as the officer starts to question you, hand him your license and your registration as required by state law. You can then exercise your right to remain silent, your right to refuse consent to search to your vehicle, and the right to an attorney for any other questioning. If the cop doesn't think he exhibits any visible signs of intoxication, there's a good chance he's going to wave you through. If he claims he thinks he has reasonable suspicion you have been drinking, now this converts into a regular detention. Situation number two, cops pull you over and they have reliable information that you are armed and dangerous. If cops have reliable evidence that you are armed and dangerous, the Supreme Court has given them more leeway to be able to detain you and potentially frisk you for weapons. Merely asking the officer, am I being detained, and then hoping you're going to be free to leave isn't going to stop an officer who has a description of a suspect involved in an armed robbery or something that meets your description. Or if the officer thought you were reaching for something that he believed placed him in fear of serious bodily injury or death, by placing his officer's safety at risk because you are reaching for a weapon. And finally, watch out if you live in a stop and identify state. In some states, the law requires you to identify yourself when cops have lawfully pulled you over and detained you. These are often called stop and ID laws, and they first came about in the Supreme Court case of Hybel versus 6th Judicial District. If you live in one of these states, you must give your name, usually your ID, and in some states your date of birth if questioned and asked for by the police. Failing to do so can actually be a crime in those jurisdictions. So, if you live in a state that's a stop and ID state, what exactly should you do? If you're detained and the officer demands you identify yourself, provide your name, your date of birth, and your ID as required by law, but then provide no other information. You can still exercise your constitutional rights, and it is important that you do so. Just choosing to be silent and quiet doesn't mean you've invoked your rights. It's important to say, officer, I have nothing else to say. I exercise my right to remain silent, and I do not consent to any searches, and I also exercise my right to an attorney to be present for any future questioning. Remember, using the magic words, am I being detained, can't be used to get you out of legitimate legal situations, legal requirements in your state, but it can be used to protect you from police officers using tricks, lies, and other techniques that are stomping on your constitutional rights and trying to trick you so that officers can arrest you or search you for something altogether different. So the ultimate point is, please know the laws and the rights that you have in your specific state. And anytime you start being taken advantage of by the police, you can use these words, "Am I being detained?" to protect yourself, and then you need to be in compliance with your other state laws. This new Supreme Court ruling with Barnes has sent a clear message that if cops try to play games with you and you assert your rights, the courts will now be forced to back you up based on this 9-0 decision. So remember, the next time you get pulled over and you start feeling like the cop's taking advantage of you, when you use those wonderful words, "Am I being detained?" you're not just throwing out a catchphrase, you're actually wielding the power of the Constitution. The Supreme Court case of Barnes welded together decades of case law to reinforce a simple but powerful idea. If cops want to detain you or use force against you, the entire encounter must be measured. And if the officer doesn't play ball, but you follow the law, what he chose to do and how he treated you can now be used against him. Now, we just covered the 4 words you can use to stop a traffic stop dead in its tracks. But did you know there are tricks, legal tricks cops can use against you during a traffic stop? Check out this next video where I break down how to stop cops from using tricks against you during a traffic stop. See you over there.